Good evening and welcome back to the Canadian Concussion Center's webinar series, which is sponsored by LAUNA, the Labor's International Union of North America. My name is Leslie Rattan, and I'm really pleased to be moderating our session tonight and our series, which was developed for individuals that have sustained concussions, their caregivers, as well as healthcare providers. And if you've been with us before, you'll know that we start off our talk typically with expert speakers, and then that is going to be followed by a period where you can get your questions answered. And our sessions are recurring every other Tuesday evening from 6 to 7 p.m. Before going any further, I'd just like to acknowledge the Indigenous peoples of all the lands that we are on today. Even as we meet virtually, it's important to recognize the lands we each call home and reaffirm our commitment to improving relationships and understanding with local Indigenous peoples. From coast to coast, we honor the ancestral and unceded territory of all the Inuit, Métis, and First Nations people that call this land home. So just as a reminder, especially if this is your first time here, if you do have any questions this evening, if you just move your cursor to the bottom of the screen, you'll see a Q&A. So please just enter your questions there. You can put those in at any time during the talk during the talks or after. If you are having any technical difficulties, please enter those into the chat. If you click on the chat right now, thank you, Christian. Christian has entered the link to the Canadian Concussion Center website where you can find all of our prior recordings. So if you missed any of our previous webinars that you might be interested in, you're able to access those there. And that will be the same for tonight's webinar as well. As we do every week, we're just going to run a short poll. So I'm just going to ask Christian to pull that up. We'd like to get a sense of who is in the audience. So I will just wait for that to pop up. Okay, fantastic. So for this evening's session, I'm really pleased to introduce Dr. Charles Tator and Patrick Brown. We're going to be hearing from both of them, and they're going to be talking about the legal and legislation and guideline issues around concussion. So I'm going to introduce both Dr. Tator and Patrick Brown, and then I'm going to turn it over. We're going to hear from Dr. Tator first, and then from Patrick Brown. So Dr. Tator trained in neurosurgery and neuropathology and was chair of neurosurgery at the University of Toronto. He headed neurosurgery at Sunnybrook, Toronto Western Hospital, and University Health Network. He was a founder of Think First Canada, a national brain and spinal cord injury prevention foundation, and Parachute Canada, a national injury prevention agency. He is a scientist in the Krembil Brain Institute. He held 2 research chairs at the University of Toronto and is an officer of the Order of Canada and an inductee of the Canadian Medical Hall of Fame and the Canadian Sports Hall of Fame. In 2009, he founded the Canadian Sports Concussion Project and then the Canadian Concussion Center in 2015, both at the Toronto Western Hospital, specializing in patient care and research in concussion. He's also the author of 447 publications, and those continue in peer-reviewed journals and books, and is a member of several journal editorial boards. And Patrick Brown has been practicing law for over 25 years and has dedicated his career to helping those who suffer serious and catastrophic personal injuries, as well as families who have lost a loved one due to the fault of another. He has handled cases throughout Ontario and is a recognized leader in personal injury law. He is a certified specialist in civil litigation by the Law Society of Ontario and has been ranked most frequently recommended by Lexpert, the highest ranking a lawyer can receive. He has also been granted the AV preeminent rating from Martindale-Hubbell, which is the highest possible rating in both legal ability and ethical standards. Additionally, he was elected as a Fellow of the Litigation Council of America, an honor awarded to less than 0.5% of eligible lawyers. So with that, I'm going to turn it over to Dr. Tator to start.
Well, thank you, Leslie. And can everybody see my slides?
Yeah.
Christian? Good,
Yes, I can
thank you.
see them.
So, laws and lawyers are important for the treatment of and prevention of concussions. And I'm so pleased that Patrick Brown is on the program again this evening. He's been a friend and colleague for many, many years and has so much to offer in this field. Okay, so Leslie has already talked about these, so we can skip over that one. I just will show this slide to remind everybody how multidisciplinary concussion is in terms of treatment, that people have to consult several specialists in care, whether it's, neuropsychology or neuroradiology or a pain specialty or neuro occupational therapist or physiotherapist, etc. So it's a really very much a team activity. And the features of concussion that I think are important is that most people do get better. So about 75% have complete recovery in about a month. If it's your first concussion, the chance of recovery goes down as the number of concussions go up. Um, and those listening tonight, I'm sure, are part of the 25% who don't recover promptly. And so hopefully we're going to give you some clues about how you can improve your recovery. And it's usually a diffuse injury without any focal deficits. And very often the symptoms are very subtle, like nausea or dizziness or difficulty with light. And in fact, there are about 65 symptoms. Not too many people lose consciousness, but about 5% do. And to remind you that there's no accurate way of grading a concussion. So, some people say severe concussion, but a concussion is a concussion is a concussion. And also to remind you, there are no biomarkers that have been discovered. And although advances are being made steadily, we still do not have a biomarker. So what you tell the healthcare professional is important for that person to make a diagnosis based on your signs and symptoms. And this slide is of interest because it does show the complications of concussion. And that is one of the reasons why we're fussing about this now as a medical practitioner, whereas when I first went into practice, concussion wasn't even taught in medical school, but it is now because of the importance of the acute concussion and then this problem of second impact syndrome, that if you get another concussion before you recover from the first, and especially if you're younger, then it may cause very serious consequences, as in the case of Stringer. And then post concussion syndrome, which most of you who are listening to this have, the psychological consequences really are quite common, and at least a third of people will become depressed or have anxiety or panic attacks. And then ultimately, this issue of brain degeneration, if you've had many concussions, especially in the sports and recreational field, and if they've been very close together, that can result in a long-term effect. We see a lot of people who are concussed every year. In fact, it's probably the commonest brain injury by far, and it affects about 1% of Canadians every year. So imagine every year there are about 400,000 people in our country who get concussed. And the consequences are important, as we have said. We would like if every person learned how to recognize a concussion, so that if you don't recognize it yourself, then maybe your spouse will recognize it, or the coach of the team, or the teacher in the classroom, or a colleague at work. So we'd like the knowledge of concussion to be right across everybody. But to get diagnosed, you really have to go to a doctor or to a nurse practitioner. In some provinces, physiotherapists are licensed to diagnose concussion, but not in Ontario. In Ontario, it's got to be a nurse practitioner or a physician. And to remind you, the causes of concussion are many. We used to think of sports and recreation being the most common cause, but it is just one of the causes that we recognize now. So there's motor vehicle crashes, there's intimate partner violence, other assaults. Concussions can occur at school, falls in the elderly, sports and recreation. And now the new considerations are that there are concussion laws in many places, including the province of Ontario and in all states of the US. And we should all play a role in trying to prevent the next concussion. And you may, be somewhat surprised that we have this particular session that includes legal issues. And we want to make you aware of the fact that you may need to have a lawyer. There are many reasons for needing a lawyer to help you get through the ravages of concussion. And we're fortunate to have Patrick on board tonight to answer many of the questions that you may have that relate to legal aspects. And this just lists in red when you would need a lawyer. For example, work-related injuries, lawyers are sometimes needed if the employer doesn't behave properly. Motor vehicle crashes, frequent cause for needing a lawyer. Even a fall, walking along the street, there's uneven pavement, you trip on it, you may need a lawyer to help you recover some um, some benefits. And then obviously, if it's a criminal activity like intimate partner violence, then you're definitely going to need a lawyer. And other criminal activities come in there as well. So many reasons for needing a lawyer. I just want to remind you that we actually now have a concussion law, and that law really stems from the death of Rowan Stringer, who was age 17 when she died in Ottawa in 2013 from the effects of repetitive sports concussions and second impact syndrome, a very rare uh, complication of concussion, but nevertheless so important because it can be deadly, especially in young people. And as a result of that, in Ontario, our Ministry of Education, the Ministry of Sports, and Ministry of Health all got together to have memoranda of management called PPM 158 initially. And then in 2018, in our province, we passed Rowan's Law. And that, I think, has really been helpful in bringing education about concussion to all the young people who get concussed, and to their parents and to their teachers. So it's been a terrific thing in our province. Other provinces have other measures that have been brought in as well over the past few years. This is a picture of Rowan Stringer, and as a result of an inquest at which the lawyer involved was extremely helpful in bringing out the fact that she had had previous concussions in the same 10-day period between the time of her first concussion and the time she actually passed away. We still don't know the exact mechanism of why the young brain swells so much to cause this condition, but the good news is that it's completely preventable by preventing the second hit. And so it's so important for kids to tell when they have been concussed. And now uh, the concussion laws in Ontario cover everybody who's in a league or who is under 25, so it covers all university students, for example, as well as elementary and high school students. So it's been a really terrific thing to have Rowan's Law in Ontario. And the Ministry of Tourism and Sport has been especially active in having reminders about Rowan's Law every year. And this is what parents and guardians are required to read and to sign in order to have a kid play in sport. So this is a big a positive for prevention of concussion, that there's so much awareness now among coaches and team trainers and if you ever want more details on this, it's in the minister's progress report. And this is just showing the 2021 report, but every year the ministry is required to report on the progress made with Rowan's Law. My daughter, who's an elementary school teacher, tells me that this poster is a reminder that's present in virtually every school in the province. So this brings us down to, who makes the diagnosis, and it's very important to go to an emergency department or to your family physician to get properly diagnosed. But even then, you may run into someone who's just not fully cognizant of concussion. And in fact, there is a paper that I've read recently talking about probably 25% of people who are concussed and go to an emergency department won't get the correct diagnosis. And it's often because they also had another injury, like a knee injury or shoulder injury, and that's more obvious to the practitioner. So it's not easy to make the diagnosis. And the other thing about making the diagnosis is the fact that we don't have a biomarker, and this just emphasizes that we still do not have a biomarker. For example, when you go to the emergency department with chest pain, you're going to have a blood test done immediately, and it'll tell whether or not you've had a heart attack. Well, we don't have that in concussion. It depends on the skill and the knowledge of the examining doctor. And of course, and this just shows that this is a perfectly normal MRI. If any of you have never seen an MRI, and this is a concussed patient, and it just doesn't show up on an MRI. So there is no accurate biomarker yet. So the answer is still no, but we're hopeful that, in fact, the whole world is looking for a reliable biomarker. So there's a lot of activity going on to try to discover it, but it isn't available presently. So if you've had a concussion, you need a doctor or a nurse in the province of Ontario to make the diagnosis. And this is another example of the improvement in knowledge that the Canadian guideline on concussion in sport, which is used by all teams and all schools with programs in sports that may lead to concussion. And these guidelines were updated in 2024. This was done by the Public Health Agency of Canada. So not only are the provinces involved, but federal government is also involved in enhancing concussion. There are a number of other organizations that we want you to be aware of. One of them is the Ontario Brain Injury Association, that they have a number of services to help people with concussion get to the right place at the right time. They offer support, education, advocacy. So I definitely want you to be aware of OBIA. And in fact, on the OBIA website, you can find this tip sheet for selecting a qualified trauma lawyer. So that is relevant to our discussion tonight. Which lawyer is best to handle your case? And it brings me up to this slide, which shows the websites that you can go to for extra information. There's a lot of good information now on the internet about concussion. There's a lot of advertising that can be confusing. For example, some practitioners who aren't as knowledgeable as others have very flashy websites. So you do have to be careful. And so looking at a list like this of reliable websites may help you in your search for appropriate treatment. And by the way, all of these slides with all of the information is available on the Canadian Concussion Center website. And I checked it last night, for example, and each year it's getting easier to use. And it's just right there and available. And this session that we're presenting tonight will be posted on the website in a week or two. But the previous session that Patrick and I did about a year and a half ago, which I watched the other night just to prepare for tonight, is also available to you. So please avail yourself of a huge amount of information that is available on our website. So I think that brings me to the end of my presentation, and we'll go on to Patrick.
Firstly, I did want to say thank you so much for your kind comments, Dr. Tatter. I'm just getting this set up. I have had the very fortunate and privilege and honor to work with Dr. Tatter over the years, and I can say that not only obviously is he an esteemed medical professional and done so much in the medical field, but where I've had the opportunity of watching him and listening and working with him is in relation to risk and awareness and bringing a lot of the information about concussion and prevention to the forefront that when certainly I started well over 25 years ago did not exist to that extent. And it has made a world of difference to the legal community and the ability of lawyers such as myself to advocate on behalf of people who do suffer concussions. And I did want to just say thank you so much, Charles, for everything that you do. Now, do you need a lawyer because you've had a concussion? I think as Dr. Tatter's already indicated, 75% of concussions resolve themselves within 30 days. So for that 75%, in all likelihood, you do not need a lawyer. Unfortunately, the way our law is set up, with some exceptions, but for the most part, there's not much recourse a lawyer is going to help you with a concussion that resolves itself within 30 days. We really are looking at individuals who need help because their concussion symptoms are persisting. And as an individual, you'll find that out from your medical practitioners as to, are my symptoms obviously you would know are persisting. How long will they last? And these are all really valuable questions that you want to deal with the health professionals as you move forward after you suffer a concussion. And hopefully everything resolves and you're part of that 75% and you never have to speak to someone such as myself. But unfortunately, I think for many and likely the people on this program, it has had an impact on all aspects, some aspects of your life, whether it be social, whether it be able to work, dealing with your family, your education. You might have been dealing with multiple accommodations. Money issues seem to flow in. As Charles indicated, if you're suffering with a potential of 65 symptoms that can pull into other types of conditions, clearly that can have a financial impact on you and your family, and you need help. Sometimes you need help where the OHIP system is providing you care, but unfortunately it doesn't provide the care that you need, and you at times need services outside of that to assist you, whether it's physiotherapy, neuropsychology, psychologists, or other practitioners that work within this field that help with individuals with concussions, social work, etc. You may have impact with your childcare and need help with it. You might have an elderly parent that you're no longer able to look after. And of course, there might be other aspects of counseling that you need. So do you need a lawyer? Well, if your symptoms are persisting, it's having an impact, and you need help, then you may very well need a lawyer and speak to them to find out where that help could come from. Charles touched on it a bit, where these concussions can arise, and he's giving you kind of a wealth of different aspects in life where concussions can be a result of a fall or something at work. It can be involved in relation to a car crash, obviously sports and recreation, a fall on ice. When the concussion happens, people may need the recourse of different services to help them get better. And some of them are charitable organizations like the Brain Injury Associations and the various ones in your locale. You can have OHIP, where OHIP services are provided by our health system to get better. You may need short-term disability, which is simply payments from your employer while you're getting better. Usually that's lasting within a certain period of time. Usually it's 100% of your income. If the concussion symptoms persist or it goes on, you can move into more of a long-term disabled type situation where you may have long-term disability you need from work, or CPP disability, which requires an application. There are certain things that happen at work that you have to go through workers' compensation. You're not entitled to sue. It really depends on the event, but that whole system is set up also to get you treatment, assist you, and give you some financial services. Of course, some individuals who don't have access to certain aspects like LTD, CPP, workers' comp, they find themselves at times also needing social security nets to get income coming into the home. And that could require an ODSP, the Ontario Disability Support Plan application, Ontario Works. Course, for those individuals suffering concussion from auto crashes or crashes where an auto is involved, of course, there's a whole benefit network that's available to those individuals that is extremely complicated, actually more complicated than perhaps a tax act, and very hard to navigate. So in that wealth of different aspects, you may need a lawyer, and they may have to drive and give you advice on how to navigate those situations. Of course, there's lawsuits, and I'm going to talk about lawsuits, but lawsuits arise from all different types of activity. Charles touched on those, but the essential aspect of a lawsuit primarily focuses on someone being at fault. Someone caused the injury to you. It's called negligence. They didn't take reasonable steps to put salt down on their driveway. Perhaps a sports injury where they didn't follow Rowan's law, and because they didn't follow that standard, the individual suffered a concussion that did not get better. Of course, we all know how the rules of road works with car crashes, bike crashes, pedestrians getting struck far too often, school incidents, and of course, boating crashes. The essential thing of a lawsuit, though, is generally someone has to be found at fault for you to receive compensation. So when should you contact a lawyer? Well, clearly, if obviously things aren't getting better, things are impacting you, but you have to remember that there are some strict limitations that can really prevent someone, even where they may have a legitimate lawsuit, from pursuing it because they didn't follow certain steps early on. One of the major ones is called a limitation period. It's really a period of time that a person must initiate a lawsuit. That means issue a statement of claim in the court. That is, when you hear somebody getting sued, that's a lawsuit through a statement of claim that's been issued by the court and served on the defendants. That's got to be done generally in most circumstances. There are other limitations, but generally it's 2 years. It's 2 years from a car crash. It's 2 years from many other aspects, but there are a whole wealth of different limitations. So it's always very important to talk to a lawyer to find out what those are. There's notice periods. It's different than the lawsuit. This is where you simply have to give a letter to, let's say, the city of Toronto or the city or municipality on a slip and fall on ice on a sidewalk. Well, there's a 10-day notice period that you have to give the individual city by notice to the clerk. Same thing with a private property where someone has a fall and you've suffered a concussion. There's a 60-day notice period that you have to give that private property owner notice of a potential lawsuit. Workers' comps, generally 6 months. And then, of course, some of the auto insurance benefits is notifying your insurer within 7 days. Many of these notice periods do have some wiggle room if there's reasonable excuse, but no matter what, you want to talk to a lawyer to make sure that you know when that notice is and get the notice out properly. Finding a lawyer. Hey, listen, just like everything out there, not all lawyers are the same. Some are good, some are bad, and it really depends. Some are not even specialized in the area. So if you suffer a concussion, and depending on the nature of how you suffered it, and it is likely something that may have to pursue a lawsuit, you want to find a lawyer who specializes in that area. And you want to find one that specializes in what's called plaintiff litigation. Plaintiff litigation is the side where the lawyer actually does the suing. You also have defense insurance litigation where they defend, and that's what they do on behalf of an insurance company who's the one defending the lawsuit, usually in most circumstances. You want to find a lawyer that likely specializes solely in plaintiff, personal injury, because that's all they do. That's all their offices do. So always make sure you find that out. General practitioners are good depending on who they are, but they don't specialize in the area. You have to ask around. I mean, many of us now go into the internet to look for anything, but the internet can provide all kinds of information and disinformation. Everybody's the best of the best. Everybody can promote themselves. You've got to ask around outside of that. Ask around their peers and other people who's good in the industry, who does a good job, what kind of practice do they have. Ask around, and you will get information that will help you selecting a lawyer. There are what are called peer review sites. So that's where other lawyers, such as myself, every year go and vote for other lawyers. And we vote who we would recommend or would refer to and that we think are good. These legitimate peer review sites are like Best Lawyers, Lexpert, Canadian Lawyer Magazine, and all of them is where the lawyers will vote and recommend different individuals. And you should check out those sites because they'll give you some more assistance in making sure you find the right person. Big question is, where do they get their cases? Are they on a billboard? Are they on television? Is that where they're getting their cases? Or are they getting their cases based on their reputation? And that's a big difference. Some people who practice law practice in what's called volume operation, which is I'm going to get as much in as possible, turn it over, charge, and move on. Others will take a more restrictive set number of files in their cabinet at any given time, have a larger staff, and focus on those files with the intent of building them up and making sure that there's a reasonable resolution at the end of the case. So you want to find out the type of practice they have. And how many cases do they really carry? Are they a volume operator, or do they pick and choose how many they keep in their cabinet at any given time? Those are all important things on choosing a lawyer, but the choice itself is very important because this is obviously could be one of the biggest decisions you have to make. You're going to see doctors and health professionals that you know are good in the area of treating concussion. You should be also looking for a lawyer, if you need one, that also specializes in dealing with concussions and dealing with individuals with those injuries. You may be concerned about, well, that costs a lot of money to go and talk to a lawyer. And the lawyers in this industry that practice in the area that you will need, in all likelihood, only do it on a contingency fee arrangement, and they all give free initial consultations. So there's nothing wrong with you picking up the phone and calling them and speaking to them, because they won't charge you. And then if in fact they take on your case, they will enter into a contingency fee, which is simply meaning they're not going to ask you for any money at any time during the course of the case. They will only ask to get paid at the end of the case, and they will take a percentage of the amount that's awarded to you, and they will finance the reports for the various doctors or engineers to help you build up your case. So it's one of those situations that in that industry, primarily, most individuals suffering are not able to afford to pay an hourly rate, and therefore the industry works on solely, almost exclusively, on a contingency fee arrangement. So, lawyers and concussions. I mean, Charles has already indicated the unfortunate aspect is for many people suffering concussions, they're not any biomarkers. Many people don't have positive imaging that detects some injury to the brain. And therefore, in many of these cases, they're based on the subjective complaints of the individual. And because of that, they're more difficult than perhaps, let's say, a case involving a fracture with, internal fixation, where everybody can see the injury. A photo or the x-ray can be put on a screen. With spinal cord injuries, many of those you can show the extent of the injury. People with certain types of brain injuries will have positive imaging, and that can be shown as well. But with many of the concussion cases, there's simply no objective evidence that the other side will say shows the injury, and therefore it's based on subjective complaints of the individual. And because of that, like concussions, like chronic pain, like certain psychological conditions people suffer from, they are treated with suspicion by the defendants who are defending those claims, which are primarily insurance companies. And many times they are hard fought and they are attacked. And the one area they attack is the individual's credibility in order to show that they're not telling the truth. And therefore, one should not necessarily believe the subjective complaints that they're giving. And therefore, that's how they attack these cases. And for any lawyer dealing with, their key goal, as the individual is to try to protect the individual in relation to them attacking that credibility and moving forward to prove the case and showing that this is a real disabling condition that has a huge impact on the person's life in certain cases. So how do you do that? Well, firstly, the lawyer has to make sure that, well, these are some of the things that you can actually do to protect yourself in order to dissuade that suspicion from you. One is preserving evidence so that people can actually see the scene, perhaps a mechanism of the injury. Photos of any head injury is always important to take at the beginning. It's very important too, and you may think this is counterintuitive on some of the notice things I've talked about, but it's very important to wait and see how the injury progresses. Because if you come out and you're seeking to have a lawsuit within 2 days of a concussion, well, we already know 75% of these cases, and we will resolve themselves within a month. In all likelihood, a physician or somebody's told you that, Therefore, it will look more suspicious if you try to seek litigation right out of the gate instead of necessarily waiting to see how things progress. Very important that you report your symptoms regularly to your physicians. The reason is you don't want them to suggest, oh, you really couldn't have had that because you never told your doctor. Or that symptom didn't occur until you had this subsequent event and it mustn't be related to this particular accident. It's very important that you report your symptoms regularly. As Charles had indicated, many people focus on their acute injury. Let's say it's complicated with a fracture or some other trauma, but they fail to report the other symptoms that might be indicating the person suffering a concussion. So make sure you report all your symptoms, but regularly. Follow up on treatment. Do not let them suggest that you're the victim of your own misfortune because you never followed up on what the good doctors told you to do. And you don't want that coming back. It's something that it's a defense, and it's a valid defense that they can assert. And therefore, everybody has to mitigate their damages. So always follow up with the treatment. Be proactive in the medical system. The squeaky wheel does get the grease. I see it. I know the individuals that really are more proactive on seeking other advice or things within the system. I will tell everybody, if you want a good case, there is one factor that your lawyer is going to expect, but it's also the one that's going to enhance your case the most. Honesty, honesty, honesty. Be honest throughout. And don't try to gild the lily. Don't exaggerate your claims. Don't try to hide any pre-existing conditions. All that comes out. But if you're honest throughout, that will enhance your case. It will not hurt your case. And stay away with what Joe the neighbor or someone else tells you. Usually it's bad advice. Every case is different. And don't necessarily listen to people who are not lawyers or have not dealt with these types of cases. I will tell you this, no matter what, in relation to beforing a lawsuit, you should understand it's always way better to have your health than a good lawsuit, because a lawsuit will never give you the full compensation you're entitled to. The system simply is not designed to do that and does not do that. Lawsuits carry risk. The process is long and taxing, and you should understand that you are very much an open book. Your clinical notes and records are going to be produced. They're going to be reviewed by an insurance company and a defense lawyer, and they're going to pick at it to find openings to attack you. You're going to be also subject to examinations by defense doctors that will examine you and prepare reports. They are selected by the insurance company or the defense lawyers for a very specific reason, to provide a report that in all likelihood may reduce your claim and your entitlement. They will subject you to what's called validity testing, which is neuropsychological testing, in order to determine whether or not you are not telling the truth or gilding the lily or malingering, and they may make these accusations against you in order to defend the case. Those are serious accusations, but they have to be responded appropriately. They will also follow you with cameras, take pictures, videos, all to see whether or not you're doing things that are contrary to what your medical reports may suggest or what you may have said under oath during your examination. These are all ways that they're going to attack your credibility in order to reduce your entitlement. Now, is there bias within the legal system when it comes to concussions? Yes, there is. And I don't say that it's throughout the system, but from time to time it arises, and we see it in cases. Medical experts on the other side earn considerable money doing reports and testifying. And at times, some testify only for the defense. Medical experts in the area of concussion, you must understand, do not all share the same opinions when it comes to concussion. They don't necessarily all share everything that Dr. Tator would say in regards to concussions, how they come about, how long they can last, and how they can impact a life. They do have at times competing opinions, and that does exist. And if you look at certain cases, the courts have acknowledged that there are certain experts that may have an element of bias in them, depending on what they say, and they look for that. But I'm just saying, from time to time, it does creep into our system. You also remember that in many cases, jury notices are filed. Juries notice, any party can put a jury notice in, meaning I'm asking that this case be determined by a jury. Many defense insurance companies will file jury notices because from time to time, certain jurors may also have some bias, I believe, in relation to feeling concussion is a real condition that can exist for some time. And that especially if they feel they can attack the credibility of the individual, they will use a jury notice. And the fact that there may not be any objective evidence in the form of photographs, x-rays, or otherwise to show the injury works against sometimes the individual in front of a jury. So, oh my goodness, how can I ever deal with this system against me when I have a concussion? Well, there's many things that you can do, and your lawyer will do. They'll use people that know you before and after this particular incident to say, wow, are they ever different? Here's the things they did before, and they did it so well, and now they're doing this. They're not functioning in the same way, and those are called before and after witnesses, and they're extremely powerful when anybody listens to them about who the individual is. Be honest throughout the whole process, including tests and examinations. Don't try to think that you can outthink a validity test. You will fail. That's not the way to go about it. Just use your best effort throughout. Stay away with certain words like absolutes. I always do things. I never do these. Those things can, and I won't get into it, but can have an impact on your credibility. Remember, when reporting your symptoms, you could have good days and bad days, but make sure you explain that was a bad day, but some days are good. Make sure you explain that there is a wealth of different aspects of your condition as opposed to pinpointing it into a pigeonhole all the time. Always admit when things get better. If there's a certain treatment that helps you, yes, admit that it gets better. That enhances your credibility. Seek accommodations. Give things a try. That's much better than never trying at all because they will ask you that one day. Did you give it a try? And if your doctors think it's good for you to give it a try, give it a try. Because even if it fails, it enhances your credibility that you gave it a try. One of the big things about any of these cases and doing well is being nice, likable. It's a real key factor because they know if a jury notice is filed, likability is going to be a huge issue. Have good experts in your corner who also treat. I say that because there's many people in this industry that prepare reports but haven't treated anybody for years. And they have way more credibility in front of any trier of fact if they're a treating practitioner that's providing that opinion. So if I have a lawsuit, what do you get? I mean, if you have a successful lawsuit and you've proven that the other side's at fault, you'll be awarded an amount for your pain and suffering. You'll be awarded an amount for your loss of earning capacity. You'll get any monies that you spent towards your injury. You'll get a future care cost award, which is the actual things that you may need in the future to help you, so long as it's reasonable, necessary, and fair. And then as well, your family members may have claims because you suffer an injury. There's an aspect where they can make a claim for what's called loss of care, guidance, and companionship. On the pain and suffering, just remember, we're not the United States. We don't have multi-million-dollar awards for pain and suffering. The most anybody can get in Canada is $450,000, and that is restricted to the most egregious type of injuries, such as quadriplegia or severe traumatic brain injury, requiring 24-hour care 7 days a week. Concussions, generally, based on my research, and I do have charts, courts are giving ranges, and because there is a wide range of individuals and how they suffer from concussion and how long they last, is they can range from anywhere from 75 to 250,000 on concussions or mild traumatic brain injuries. This is very important. Many people in car crashes will have benefits available to them. They may try to stick the individual into what's called the minor injury guideline. That's very bad because that only offers $3,500 worth of treatment to that individual. Anybody who has a concussion is not to be under the minor injury guideline. They should be in what's called a non-catastrophic designation that will give them $65,000 worth of treatment or up to 5 years. but it's very, very important that you want the diagnosis to be that you're suffering a concussion. It doesn't necessarily need to come from a neurologist. It can come from other practitioners. We've seen that by a number of decisions. So just remember, though, as Dr. Tatter had indicated, that when you're seeing those people and individuals and they're focusing on other things, if you did suffer a concussion, it's very important that that diagnosis be given so that that can take you into this other aspect of the accident benefits. There's been some really good decisions just about, concussion and that it's to be taken out of the minor injury guideline. Doesn't have to be necessarily a neurologist, and it certainly can be derived from very slow impact collisions as well. Thank you. Hopefully I've left some time for questions, and I hope some of that information helped you. I know I touched kind of very broadly on a lot of different areas. If I can give you one advice is if you have ongoing symptoms, it's having an ongoing impact, just make sure that you do speak to a lawyer to see if there's any help that they can provide you in relation to that aspect that you haven't recovered from. Thank you.
Great. Thank you so much to both of you. Really great talks. We do have a few minutes. Okay, so I'm going to jump right in. Are there any lawyers in the Toronto area that will help with WSIB? With no large settlements, I understand they may be reluctant.
That's a great question. And the unfortunate answer to that is there are very few, if any, lawyers that you will find in the GTA that's prepared to take on a WSIB case. And I will say that there are some, and there are some very good ones, but they're few and far between. And I'll tell you why. The reason that is under the WSIB system, they don't lump people out. They pay based on your income. Replacement will be paid out to the individual. The treatment will be provided to the providers. And unfortunately, there's no significant lump sum award that will allow a lawyer to work on a contingency basis. Some lawyers and some paralegals will do it on an hourly rate, but that's very difficult for an individual to pay an hourly rate when they have no real money coming in sometimes. So it's really a hole in the system that doesn't really exist. There are paralegal companies that will do WSIB and paralegals that are very apt to do it, and some could do a very good job. But on finding lawyers, you'll have a very difficult time.
Mm-hmm. Great, thank you. Yeah, there was another question too around WSIB. What if you had work injuries and reported to WSIB and got some treatment, but years later you still have persisting symptoms? Can you go back to them?
I don't do all WSIB, but that's certainly something that you should take a look and canvas and see whether or not there's an opportunity. But there are some limitations with WSIB in relation to certain conditions. If it's if it's the same condition that gave rise to the initial payments and you continue to suffer and you haven't been denied that particular benefit yet, then it's certainly something that you can attempt to see if you can be receiving ongoing treatment or compensation for. If they're relying on a denial and it's been denied and not appealed, you may be out of luck.
Okay. I think this one is more for Dr. Tatter. If you have daily headaches after a concussion, how can doctors be sure that it's the concussion and not a possible brain tumor?
Uh, that's a great question. And the answer is that the signs and symptoms of a brain tumor can be very specific. For example, if it's causing double vision, it points to a certain part of the anatomy that aren't injured in a concussion, but can be affected by a brain tumor. So signs and symptoms help. Of great help, though, is imaging, because almost all brain tumors like that are over, let's say nowadays, 1 to 2 millimeters in size can be detected by MRI. So MRI is quite marvelous to show whether you've got a brain tumor or not. And frankly, we even though we don't have an imaging biomarker, we do suggest that you have some imaging to do exactly what this question is designed to discover, and that is there another condition present that is being overlooked and just considered to be part of the concussion. So most practitioners in the concussion field will be very careful and will get imaging done if it's indicated. Yeah.
Great, thank you. Upon settlement in a car accident case, does the TBI victim have to sign a settlement clause stating the other party isn't at fault, even though they are at fault?
That's a great question. At the end of any case, where there is a settlement, that part of the settlement terms will be that you have to sign what's called a full and final release. That release is where it gets sent to the defendant insurance company or defendant lawyer. It's kept to prevent you from suing them again once they pay you the settlement proceeds. In the vast majority of those full and final releases, there is a term or a clause that says that by signing this release, you acknowledge that the defendant is not admitting that they are at fault. And that is kind of a standard clause in there that they put in for the purpose of them trying to suggest we're not admitting we're at fault, even though they are. And if you don't sign it, you won't get your settlement.
Mm, okay, thank you.
What you should be careful on those things is sometimes they also try to sneak in what's called a confidentiality clause, which is saying that you got to keep all the terms of the settlement confidential. And if you don't, you could be in trouble. And if that's not negotiated during the settlement, then that should not be in there.
Okay, great. If you have previous injuries, so for example, pain that you don't remember long before the motor vehicle accident, and now you get worse pain in the same areas or close to them, how, I guess the question is, how does that factor into your current case?
Sorry,
So if you've got pre-existing.
So there's a pre-existing condition or a previous injury that you don't remember that occurred some time ago, and now it's in the kind of the same area to which you're now suffering from the incident. Is that the understanding?
Sounds like it, yes.
So it's another good reason to have a lawyer, because they will ask you at some stage about have you ever suffered any type of other types of injuries or pre-existing conditions, surgeries, traumas. They ask you for your pre-existing health history and be at an examination for discovery under oath. And you should be prepared before that by your lawyer to make sure that you understand that you have to answer honestly as best you can of what you can remember. And usually in many circumstances, all your clinical notes and records from previous times will be obtained by your lawyer to make sure that helps you in identifying those areas. But if you legitimately don't remember, and it's a very long time ago, then there's nothing wrong with you just simply obviously being honest and saying, I don't remember. But then again, I just don't remember. But if you do, make sure you tell them.
Yeah, I might just add to that that's a very common problem in concussion, that somebody may have had two or three previous concussions from which they completely recovered or had a good partial recovery, and then the third or fourth concussion came along from which they did not recover. So all of that should be revealed. So you shouldn't, not reveal previous concussions, because it's perfectly acceptable to have had previous concussions from which you recovered or made a partial recovery, but then you didn't recover from your last concussion. All of that, I think, is extremely helpful to help you, but also it helps the lawyers to know the complete story.
Mm-hmm.
I like just to add to that because it's such an important point that Dr. Tatter is making. Like, if you have pre-existing concussions or concussions that have occurred on previous occasions, yes, it's very important you actually disclose it. As Dr. Tatter's already indicated, you've got this second impacts. I think second impact syndrome or multiple concussions can be progressive, and it means that the concussion you suffered that you're suing on makes you more susceptible to the symptomology. And therefore, it's important that you identify the previous concussions because we have a legal rule. It's called the thin skull rule. And it's really important to know is that you take your victim as you find them, meaning you don't get to pick the most robust, healthy individual. But if your individual that you've hurt is more susceptible because they've had previous concussions, you're responsible for all the symptoms that flow from your injury moving forward. It's called the thin skull principle, and it works to the victim's favor.
Great, thank you. I know we are a bit over time. Are you both able to stay on a few more minutes just to
Till
get a,
midnight.
oh,
I do have a bit of
fantastic.
time, Dr. Tatter.
We
No,
may be
I'm
by
good. I'm
ourselves,
good.
but
I'm happy.
okay. I'll try and get a few more in here. And then for those that can't stay, you'll be able to find this online after the fact. Here's an interesting one. If fist fighting can cause concussion, why can't we sue the NHL, for example, as a class action, boxing aside?
Well, for the individuals that I guess, well, I know Dr. Tatter's dealt with the NHL on multiple occasions. I'll give you a little bit of a legal principle why I think that you don't see it is primarily a doctrine called valenti. It's one of those, Latin phrases, but it's a legal maximum that says voluntary assumption of risk. And therefore, inside the NHL, uh, part of the game, unfortunately, perhaps, or fortunately, I don't know, but I'm not going to get into that, involves fist fighting, hitting, and checking. And that when you go in there, there is an element inside there that you are going to voluntarily assume the risk associated with that sport. And therefore, that is one defense that can be asserted. However, as soon as it's being taken outside of the ordinary ambit of the sport, perhaps an egregious conduct that simply is not even part of the sport, and we've seen it, I think, in some lawsuits, such as in the Moore matter, then there may be a lawsuit. And that's probably that it can happen. And for instance, in beer league hockey, we've had cases where somebody is hammered into the boards, suffer a concussion, and has serious consequences because of it. But it's a beer league non-contact league. Therefore, the person hitting them has gone outside that game and outside what one would voluntarily assume the risk. And therefore, there has been success on those types of lawsuits. But as to Charles, I'll leave it to maybe you know more about a class action by former players. I imagine there is against the league, maybe knowing that the ongoing repetitive concussion and impact on the individual. And you can talk a bit, I guess, about that. You probably know more about that than I do.
Well, I do know quite a bit about it because I've been involved in some class action lawsuits against leagues. The one that was started against the CFL did not succeed. The one that was started against the NFL did progress to a conclusion that cost the NFL $2 billion. So that was a very successful class action lawsuit with respect to sports injuries. It wasn't really punching or hitting. It was just the regular uh, play that caused the concussions of those players, but the lawsuit was ultimately settled. And there are numerous examples of athletes dying of punches, like mainly boxers, but other athletes as well have been punched and have died. And there have been lawsuits. Um, so they're very complicated. We would like to see, for example, fighting banned from all sports. Uh, I think there's no place for fighting in sports, and the presence of fighting, I think, spoils the sport, but it does, as they say, attract a certain clientele who want to maintain it. So the leagues are very reluctant to give it up because it puts puts people in seats. Unfortunately, I think it's one of the human flaws that there's a certain aspect of us that of some people that likes to see fighting.
Okay, thank you. Is covert video surveillance or information from the internet, like Facebook, allowed in court?
Depends, but yes, certain aspects are. We tell all our clients at the very beginning of a case, they'll have a person, a law clerk, sitting in a room that is going to go and try to look through your social media, your Facebook, your Instagram, you name it, your LinkedIn, and they're going to try to find photographs or statements in order to attack your credibility and perhaps suggest that you're doing much better than what you're alleging in your lawsuit. Yes, they do that, and you should be very, very wary of it and ensure that whatever you're posting or posted could very well find its way into the courtroom.
Thank you. We have a question asking about, so if you're working in a unionized setting, is it true that you cannot have a lawyer? I think that's what is being asked here.
It depends. I mean, if you're working in a unionized, you can have, I take it, it depends what you want a lawyer for. So for instance, in some collective agreements that is part of a union or a union member, you may have, for instance, long-term disability. But under the collective agreement, it requires you to arbitrate it through that process. And it's usually your union may be the ones that allocate the lawyer to you. If you have a human rights or employment law issue, then it's usually your union that will assist in part, I believe, in getting you a lawyer. But it really depends on the collective agreement as to what you can and can't do in relation to retaining your own lawyer for a lawsuit, depending on what the lawsuit's about and who it's against.
Okay. I'm an unpaid homemaker and caregiver for elderly relatives. Since I don't have any official revenue, does that mean my occupation was worthless? That is, not worthy of compensation?
Well, of course, it's not worthless because we know that that type of work can be extremely taxing and weary and extremely important to the individual who's receiving that care. So from that standpoint, from a legal lawsuit, in a lawsuit, albeit it wouldn't be like a loss of income claim, but it would be a claim for the loss of services provided to that individual. And it is something that our courts do allow compensation for, that if you're restricted because of your injury to look after that individual, and then you do have to have someone else do that for you, then that is a claim that can be advanced.
Um, all right, there's more. We've got a number of comments about WSIB. Someone did actually ask, how do you go about finding those few lawyers that do uh, deal with WSIB? Is there any
I
easy way
could
to
name
find them?
drop, but I mean, I don't know if you want me to name drop who I send people to. But I'm telling you, it's very difficult to find one. And so I don't have a lot of names, but I
Yeah,
always know that one lawyer who's very good at it, his name is Rob McGill out of London, Ontario.
okay.
So I did name drop. But I just,
Right.
I'm telling you, it's very difficult place to navigate for people.
Okay. Okay. I know I've gone way over. Maybe I'll ask one more. So for those of us who have persistent symptoms already from multiple concussions, so it sounds like this person's had multiple concussions. If we get into an accident, how do we show it's worsened?
Well, I mean, from a lawyer's standpoint, how we do that is primarily rely on obviously the symptomology reported by the individual, and then obviously expert evidence from neurologists, neurosurgeons, neuropsychologists, and others that assist us in understanding how that concussion could have worsened from this particular mechanism of injury. So the way it's proved is generally through expert opinion.
I might, I
Yeah.
might just add to that, that if you have sought opinion for each of the concussions along the way, then all of that evidence of did you recover and to what extent you recovered that any of your practitioners have recorded would be extremely helpful to determining the fact that you recovered to a decent level. It may have not been 100% recovery, but you did recover. But then from the last concussion, you were that much worse. So that's not an uncommon situation because we know that concussions tend to be multiple. So again, as Patrick said a long time ago, and tonight, make sure your practitioner, make sure you visit your practitioner and that your symptoms are recorded each time. Yeah.
Excellent. Okay. Well, thank you very much. Thank you for the excellent presentations and thank you for all the great questions. I am sorry we weren't able to get to all of them. But there will be a survey coming your way, so it just takes a couple of minutes to complete. As always, we love getting your feedback, any suggestions, and also if you have any questions that didn't get answered, you can also include those in the survey. You just need to include an email address because the surveys are anonymous. And finally, just to let you know, April 22nd, so in 2 weeks, we're going to have Dr. Andrea Pera with us, and she's going to be speaking about imaging, specifically in concussion. And that's it. Thank you so much, and have a great evening, everyone.
Thank you.